I'm Mike Hackard with Hackard Law. When most people think about estate planning, they focus on wills, trusts, and probate. But some of the most important decisions you make never appear in a will at all. They live quietly on the forms used by life insurance companies, retirement plans, banks, and investment accounts. These are your beneficiary designations. And while they look simple, they carry enormous legal power. In my years of helping families navigate estate, trust, and inheritance matters, I've seen well-intended plans unravel because a single form was outdated or overlooked. I've also seen how properly managed beneficiary designations create clarity, speed, and protection at a moment when families need it most. Today, I want to share the top 5 mistakes people make with these designations and how to avoid them. Mistake 1, not updating designations after major life events. Life changes, and your beneficiary forms should change with it. Marriage, divorce, the birth of a child, the loss of a loved one. These milestones reshape who you want to inherit. Yet many people never revisit their forms. I've handled cases where an ex-spouse remained the named beneficiary on a life insurance policy simply because the paperwork was never updated. The financial institution had no choice. The form controlled the outcome. A few minutes of review could have prevented years of frustration. Mistake 2, leaving beneficiary forms blank. It's more common than many think. People assume their will covers everything, so they never complete the designation. Without a named beneficiary, the account often flows into the estate and into probate. That means delay, additional expense, and possible exposure to creditor claims. The very purpose of beneficiary designations is to bypass probate. Leaving them blank eliminates that benefit. Mistake 3, naming minors without a plan. Parents often want to provide directly for their children, but naming a minor as a beneficiary creates challenges. Minors cannot legally manage inherited funds. Courts may need to appoint a guardian, adding cost and oversight. And at age 18, the entire inheritance transfers to the child outright, whether or not they're ready to manage it. A far better approach is to create a trust and name the trust as the beneficiary. This allows thoughtful, structured management of the funds over time. Mistake 4, ignoring contingent beneficiaries. A primary beneficiary may pass away before you. If there's no contingent listed, the account may again default into probate. Families often overlook contingents because they focus solely on the primary. But a contingent beneficiary provides essential backup, ensuring the asset still transfers smoothly and privately if circumstances change. Mistake 5, allowing conflicts between wills and beneficiary designations. The law is clear: beneficiary designations override wills. If your will leaves your IRA to your spouse, but your IRA form lists your sibling, the form prevails. These inconsistencies often happen when families update their wills, but forget to update their beneficiary paperwork. This can create disappointment, confusion, and conflict among heirs, all of which are preventable through coordinated planning. These 5 mistakes are the most common, but they are not the only ones. Some families overlook tax considerations when naming beneficiaries. Others leave forms untouched for decades, even as estates grow and family circumstances shift. Special needs beneficiaries require additional planning to avoid disrupting government benefits, and many families rely on do-it-yourself forms that unintentionally create contradictions across their estate plan. Beneficiary designation should never exist in isolation. The strongest estate plans integrate wills, trusts, and designations so that each supports the others. A lawyer experienced in estate planning reviews every part of the plan, identifying inconsistencies, recommending trusts where needed, ensuring proper contingents, and explaining how these choices affect taxes and long-term outcomes. The consequences of neglecting beneficiary designations are real. I've seen life insurance pass to an unintended person because the form was outdated. I've seen families wait nearly a year for funds that should have transferred within weeks. And I've seen disputes arise because a designation contradicted a will written with care and intention. But I've also seen the opposite: families who reviewed their forms regularly, coordinated them with their estate plan, and ensured every part of their strategy aligned. When the unexpected occurred, their assets transferred smoothly, their families had immediate financial stability, and their wishes were honored without delay or confusion. This is the heart of beneficiary planning: clarity, continuity, and protection. If you want to safeguard your legacy, one of the most valuable steps you can take is to review your beneficiary designations regularly, every few years, and after every major life event. Keep them consistent, keep them current, and make sure they work in harmony with your will and trust. I'm Mike Hackard. Thanks for watching.